I'm honored to be able to introduce our present Attorney General and hopefully our next Attorney General, who has served the state with distinction for 14 years and has done a good job, as his record shows on his brochure. He has several advantages. Came from a strong Democratic family in Burlington, Vermont. His mother served in the state Senate and was one of the leaders of the Democratic Party during the days when we had few Democrats. So it is my honor to introduce Bill Sorrell, our candidate for Attorney General. Bill.
Thank you, Tim. Well, thank you much to Tim and Martha and Kate O'Connor for their support. I've got strong support here in Brattleboro, and I reached out to some of Brattleboro's finest for my campaign team. And so my campaign manager, Mike Pichak, is from Brattleboro, and my right-hand man right over here, Teddy Kramer. So all I need to do is walk around Brattleboro and introduce Mike and Teddy, and I don't have to say too much, and people say we're with you. So it's very gratifying. Actually, Tim, I've been Attorney General for 15 years now, and I'm now the longest-serving Attorney General in Vermont history. Great honor to hold this job, and I think one of the real benefits of this race this year, and the fact that I have a primary, and so working hard in the summer, is that many Vermonters are learning, some for the first time, one, who the Attorney General is, but two, really what the range of issues that the Attorney General works on and how profoundly the Attorney General impacts the quality of life of Vermonters and the quality of our natural environment. And I'd like to talk just for a couple of minutes about environmental issues, because I think that as you look at if you ask the attorneys general from around the country, and pretty much without regard to their political persuasion, I think that the vast majority would say that Bill Sorrell, there's no stronger attorney general in the country in terms of defending the environment than Bill Sorrell, and that's part of the reflection of, I think, what is the ethic of so many Vermonters, and our physical environment is hugely important to us. And it's not just accomplishments from a number of years ago that I'm proud of in the environmental arena. For example, the fact that when Vermont adopted the so-called California standard, emissions standard from automobiles, and the auto industry sued us, and we defended the law in federal court here in Vermont, and successfully, and now that's the standard nationally for emissions from automobiles. There's a huge environmental benefit nationwide, not only in terms of global warming issues, but also the attendant benefits for more fuel-efficient vehicles. When you have lesser emissions, you tend to have more fuel efficiency, and so less dependence on foreign oil. So a win-win there. But that was a few years ago, and so what's happening more recently? Well, just a few cases I want to talk about. Just a couple of weeks ago, right now, the District of Columbia Court of Appeals, what many followers believe to be the second highest court in the United States, ruled in favor of New York, Connecticut, New Jersey, Vermont, and 3 environmental groups in a lawsuit that we brought against the Nuclear Regulatory Commission. And the reason that we filed suit against the Nuclear Regulatory Commission was a very important environmental question, and that was the long-term storage of spent nuclear fuels on the site of nuclear power plants all over this country. And the NRC, the regulatory body for nuclear power in this country on the national level, said it's no environmental risk. We don't even have to take a hard look at this and do an environmental impact statement. It's just going to be fine to store spent nuclear fuels in so-called dry casks on site of nuclear power plants all over this country for 60 years or more beyond the current license or relicense of our nuclear power plants. So in Vermont, down here in Vernon, we're talking about 80 or so years from now, potentially, that these spent fuels could be stored on site. And what the NRC said was, we don't have to look at this on a site-by-site basis. It's one size fits all. It doesn't matter whether a plant is near a large urban area. The governor and attorney general of New York are really concerned about that situation. We don't have to look at whether it's near a large body of water where we're going to be storing these spent fuels. We don't have to look at the geology of the plant location to see if it's on what's an earthquake fault line. No, we're not going to look at it on a site-by-site basis. Well, the DC Circuit Court of Appeals sided with the states and the environmental groups and said, no, you've dropped the ball, NRC, and you have to take a really hard look at this environmentally, and your rule that allowed you to hand down this decision is set aside. And the court went on to say, and we question the reasonableness of granting new licenses for nuclear power or relicenses for nuclear power unless or until the federal government comes up with a permanent solution for the storage of spent nuclear fuels. That NRC, you're guilty of wishful thinking if you go, not a problem, the federal government will bail us out and take care of this problem in the long run, because there is nothing to indicate that the federal government has the political will to do that. And they've just spent 20 years on the so-called Yucca Mountain site, and that has now been dropped and is off the board. There is no federal plan right now for the permanent solution storage of spent nuclear fuels. And it doesn't matter whether you're pro-nuclear power or against nuclear power or whatever, it's legitimate to be concerned about what we're going to do with the wastes, these highly radioactive wastes from the generation of nuclear power in this country. So, big win for the environment. We will see whether there's an appeal to the U.S. Supreme Court, but so far, a great victory for Vermont and several other states. And then just on Friday, we announced that Vermont was one of the states that joined in a friend of the court brief before the Ninth Circuit Court of Appeals out in the Circuit Court of Appeals for California, the far western United States. And in that case, California had adopted a low carbon standard for fuels out of concern for, again, emissions from burning of these fuels. And the trial level in California on the basis of alleged unconstitutional intrusion or impact on interstate commerce struck down the California standard. Well, there are a number of states considering adopting the California standard for carbon in fuels, and a number of states interested for environmental and other reasons in that, and Vermont being one of those states. And so we just signed on to a brief that the state of Oregon just filed in the Ninth Circuit Court of Appeals, arguing that the trial level court in California got it wrong and that the California standard for carbon in fuels should be upheld. And excuse me. What's the other one, Mike, I want to talk about? Remembering? let's see, the D.C. Circuit case, I'm sorry. I had a moment of forgetting all the environmental cases. Also on Friday, we announced a settlement of a lawsuit that New York and a number of other states, including Vermont, were in. And in that case, whom did we sue? It wasn't the Nuclear Regulatory Commission. Rather, it was the EPA. And the reason that we sued the EPA was that it had dropped the ball on meeting its obligations to update its regulations on particulate matter emissions into the environment under the Clean Air Act. And the Bush EPA back in 2005, 2006 issued new standards for particulate matter, but at that time the EPA under President Bush ignored their professional staff advisory as to what the standard should be and their outside advisory group standard on what it should be. And so it was a total political decision made by the head of the EPA and the White House, and certainly was not good for the environment. And unfortunately, even though they're supposed to do that every 5 years, upgrade their regulations, the current EPA had not met its obligations to do so. So in 2010, we turned around and sued the EPA, and we just settled that case. And the EPA has agreed to issue new standards for particulate matter, or soot, as of December of later this year. So another decision that a really good one for the environment nationally, and a good one for our quality of environment here in Vermont. So I think the fact that Vermont, the small state of Vermont, is in those cases and fighting in these cases of national import is what Vermonters want. And with me in my next term of office, you'll continue to see the most aggressive, or certainly one of the very most aggressive defenders of the environment as the Attorney General in this state. And I'll just switch to one other issue before fielding some questions. And I think as I go around the state, the positive feedback I get about the operations of our office, I hear more positive feedback about our consumer assistance efforts, both suing nationally, returning millions of dollars to Vermont consumers' pockets, also prevention to trying to avoid Vermonters getting scammed in the first place, particularly our seniors who seem to get preyed upon by these very professional scam artists. But I saw that of the 8,000 calls a year that we get at our consumer assistance program that we run up on the UVM campus, that frequently we just don't have the staff to follow those cases and to file enforcement actions as much as we want, and to do more prevention work with consumers, including businesses who, quite frankly, are frequently scammed or targeted by these scam artists. And so I went into the legislature and asked for a significant increase in our budget, something over $100,000 for our consumer assistance efforts, and was successful, thanks to support in the legislature, to increase our enforcement efforts. We went to UVM and got them to put some more money into it, and so our consumer assistance program at UVM as of July 1st is going to be bigger, better, and hopefully will educate more Vermonters to not make mistakes as consumers going forward. So those are some recent accomplishments and some priorities for my next term, and with that, I'm happy to field questions about any of these issues or other aspects of what's going on in my office.
You mentioned something about your obesity campaign. Can you speak a little about that?
Sure. During my time as Attorney General, I mean, the Attorney General is the chief law enforcement officer of the state, and you know, some people think you just enforce the laws and you just defend the laws when we're sued. But the truth is, the Attorney General wears a separate hat, and that's to sort of protect the general well-being of Vermonters. And so I have not just responded with enforcement actions, but had some areas that I thought should be studied for perhaps legislative change and such. So the first one I did was on end-of-life care and wanting Vermonters to receive the care they wanted at the end of life and not receive care that they didn't want. And it was a year-long initiative and was very well received by the legislature. We got some legislative change out of it and a lot of education about so-called living wills, durable powers of attorney. And that was the first of these year-long initiatives to enhance public health. We did one on lead in consumer products and lead in the environment, changed the laws in some respects there, changed the standards for monitoring of children whose lead levels in their blood test high, and have greatly enhanced our enforcement efforts of lead paint laws in rental housing, our older rental housing around the state. But then decided to switch to, and of course historically I'd fought a lot against the tobacco industry, and which is has been the greatest avoidable public health problem that we face in this country. Sued the industry just 4 weeks to the day after coming into office, and now we get hundreds of thousands of, or excuse me, we've gotten hundreds of millions of dollars from the settlement of that lawsuit, but we're going to get over $25 million a year, every year, forever from that settlement. But I also said, okay, what's the next biggest problem, greatest avoidable public health problem that we're facing in this state? And is there a role for the Attorney General in sort of highlighting the nature of that and how our laws and policies might change to enhance public health in the state? And as you know, as a physician, it's obesity. And we have just incredible increase in obesity rates in this state and in this country, with estimates that if we don't change course, that as of the middle of this century, very close to half of the adult population will be obese, which is like very overweight. Diabetes rates are skyrocketing, and what that's going to do for the health of our workforces, our military preparedness. We have to do something about this, and if the national government, federal government is not going to do something about it, we could do something about it in Vermont. So we had a year-long study here, and basically, you know, some say it's the nanny state and telling people how to live their lives, but you know, when the suggestion is eat healthier and exercise more, if I'm guilty of giving that advice, if the report that we put out from that was undue intrusion in people's lives, I'm sorry for that. But the legislature hasn't thought so, because they turned around and passed a complete streets law, which says that in future development in this state of highways and planned developments and downtowns and such, that the default is that you should consider bike and pedestrian friendly design for these kinds of projects. And I know that there are other legislative changes in the works in this arena, and I just think that we can and should do something about it, and I'm proud of having raised the issue and now let those with votes in the State House and the legislature and the governor's office go from there. Obviously, we're going to change our healthcare system, hopefully nationally. We'll find out from the Supreme Court very soon, but certainly in this state. And healthier Vermonters is going to be good for us, our quality of life, and our competitiveness as a state as we move into the economies of the future. I think it's near a crime that, you know, public health officials say that our kids' generation is going to be the first generation of Americans less healthy than their parents' generation. And that's when we are the policymakers making decisions. And if that happens on our watch, then shame on us. And I think we need to do more to have this next generation be at least as healthy as we, and hopefully healthier.
Yes. Thank you, Mr. Sorrell, for fighting for states' rights versus federal jurisdiction, and especially in regards to VY, of course, that does need to be shut down, a potential dirty bomb down the road. And that's something that the left doesn't seem to care too much about, states' rights, unless there's an issue like VY comes up, and the NRC having a little too much say-so in that as far as safety and all. But as far as what I would call your underlings, the local attorney generals like Tracy Shriver and Cindy McGuire.
Okay, Tracy Shriver is not an assistant attorney general. She's independently elected as the state's attorney. Cindy McGuire is an assistant attorney general and answers to me.
Oh, okay. But I understand from the reformer that both of them were somehow involved in this, what was called by some people, and I agree, a witch hunt against the Vernon town clerk, Sandra Harris, and all because of an accusation made by somebody in Vernon against her, and it turned out she was exonerated and she didn't do anything wrong. But on the other hand, the attorney generals, when someone like former sheriff of Windham County Sheriff Sheila Prue was found guilty of stealing $60,000 to $70,000 worth of public funds for her and her partner to go on trips and everything, she gets a slap on the wrist by the prosecutors and her felony reduced to a misdemeanor. What's with that discrepancy in prosecution?
Okay, first of all, those are all good points or good questions, and I'll try to remember them in order. One, I have been a strong defender of states' rights and versus the federal government, and was really pleased and proud to see that 2 weeks ago today, the state of New York filed a brief in the Federal Appeals Court in New York on the Entergy case, arguing states' rights. And that same day, it was a week ago, and the same day, the National Conference of State Legislators, bipartisan organization without not just Democrats or liberals or whatever, filed a brief saying that the decision should be overturned, the trial court decision from here in Vermont should be overturned because of the negative impact on the operations of state legislatures going forward. So without regard to red states, blue states, or whatever, strong defender of states' rights versus the federal government. On the issue of the clerk in Vernon, you use the term witch hunt, and you're certainly entitled to use that term. I would say that what happened was I have statewide criminal jurisdiction. I have the same authority in Windham County that Tracy Shriver has in Windham County for all state crimes. And when allegations of criminal wrongdoing by public officials or others are brought to our attention, we take them seriously. You mentioned Sheriff Prue. You can say that she got a slap on the wrist, but she was removed from office and convicted of criminal wrongdoing in office, as also happened to the Washington County Sheriff as a result of prosecution by my office, as the police chief of Virgins was prosecuted by our office and sent to prison, as was the treasurer of Isle Lamont for embezzling public funds. So we take seriously allegations of wrongdoing by public officials and non-public officials. And so we investigated the Vernon case. We took it seriously. I think a lot of people, if we had said, oh, that's a town clerk, we're not going to take a look at that, would be upset saying, hey, there's a dual standard of justice in the state. And the Attorney General, protects the those who were in authority. No, we took a hard look at it, and we found that there were not facts there to support a criminal charge, and we said that. So we take the oath of office to do equal right and justice to all men and women to the best of our judgment and ability according to law seriously, and that's what we did in the Vernon case. And had we just heard allegations of potential wrongdoing and said, no, we're not going to look there, I think a lot of Vermonters would be upset if that was our approach.
Okay, maybe witch hunt is a little over top, but what about the perceived, use the word...
double standard?
Double standard with if someone else, if ever Joe had stolen $60,000, $70,000, they'd probably be getting out of jail maybe now after a few years.
You know, the truth of the matter is embezzlement by not only elected or appointed officials, but by average citizens from businesses seems to be at an all-time high now. And other than cases where it's hundreds of thousands of dollars or millions of dollars that have been stolen, given the fact that we want to have violent offenders in our limited bed space in correctional facilities, the truth of the matter is, I don't want to say it's okay to steal $60,000 and you definitely won't go to jail, because I don't want to deliver that message. But the truth of the matter is, in this state right now, it is unlikely that you will be incarcerated for stealing something in the tens of thousands of dollars. It would be an unusual case. Unless you had a prior record or there was something particularly egregious about it, you would be placed on probation. And then if you violated the terms of probation, you'd be subject to going in. But
there are Vermonters in jail now for nonviolent offenses of marijuana possession.
There are, I mean, we can have that discussion. There are few in for simple possession who were not either selling or their simple possession triggered a violation of their probation or parole for an earlier conviction. There are few, if any, in jail for a simple possession, particularly of a small amount, under a few ounces of marijuana. Essentially, marijuana has been decriminalized in this state.
Who was the victim when the gentleman was prosecuted because he never had a record, and yet he's found with a couple of pounds of marijuana, and I believe the law assumes that he was selling it even though he wasn't. Yet he's facing years. I believe he's in appeal right now, Mr. Mobley. But who's the victim of the crime of mere possession of marijuana?
Well, you talk to the legislature. I enforce the laws that the legislature enacts. If the legislature wants to change the law and decriminalize or whatever on marijuana, I will follow the law the legislature enacts. But right now, if you've got a couple of pounds of marijuana, you're in trouble with the law.
What about a couple pounds?
You know, I'm happy to talk to you more, sir. I really am, but there's some other hands up, and I'm not trying to avoid your questioning. Yes?
I just wanted to ask a question about the, I think there was a recent case about the family leave.
Yep, I'm glad you raised that. Yes. Yeah, okay, I'm glad you bring that up. I've got like 76 lawyers who work for me, and we do an awful lot of different stuff. One of them is our civil rights unit, which enforces discrimination in employment by other than public employees. Okay, we don't handle discrimination for public employees. The Human Rights Commission does that. A few years ago, the legislature passed a statute on unpaid parental leave. And my civil rights unit, the question came up, do you earn vacation sick time if you're out on unpaid leave? And my civil rights unit looked at the legislation, felt that it was intended to be expansive, and opined with the Governor's Commission on Women and the Human Rights Commission that yes, you earn leave for vacation sick leave while you're on unpaid parental leave. The state of Vermont, our Department of Personnel, never accepted that reading of the law. Told us they just disagreed with it. But no one challenged the state interpretation of the law until an employee at the Agency of Transportation did. And so it went through the grievance procedure, it came up to us, and we assigned another attorney to look further into the legislative history of the enactment, and that attorney found evidence in the legislative history that indicated that the legislature did not intend that you would earn vacation time and sick time if you were out on unpaid leave. So we defended in the litigation the lawsuit or the grievance that was brought against the state. And I'll be the first to admit, we defended a position that was inconsistent with what my civil rights unit had said in the past, the advice it gave to private employers. The Vermont Supreme Court just ruled in favor of the state's interpretation that, that there was not an intention to earn vacation and sick leave if you're on an unpaid leave. And that will be the advice to private employers also. The legislature is going to be back in January, and they have every right to change and clarify if they intended other than as the Supreme Court just ruled. But our office took two, at different times, inconsistent positions. The more research we did, we defended in the Supreme Court, and they ruled that way. I apologize for that inconsistency, but we now have the Supreme Court saying what was intended by the legislature. Okay? Yes?
We have the extraordinary privilege of living in a state that allows members of the same sex to get married. And I'm wondering, as you said, a believer in states' rights, is there more that you and your office can do to support other states that are really struggling with how to...
Well, we'll support Massachusetts in its lawsuit against the federal DOMA. I was in touch with Martha Coakley, the Massachusetts AG, at the trial level, and saying, "Do you need any help, Martha?" Or General Coakley, and she said, "No, I think we're good now, but when it gets on appeal, we'd like your assistance." And I said, "Great." We already had issued an opinion, also from our civil rights unit, that under the Vermont's anti-discrimination law, that transgendered status was a protected category, even though the statute did not say transgendered, that we said this was intended, but we suggested to the legislature the next session. We have issued this opinion. It got some national play for an attorney general opining that this was covered under the state's anti-discrimination law, but we suggested to the legislature it'd be really good if you spoke specifically to this, and the legislature did, to clarify that. So we also went into the legislature and got permission or authority for our office if someone is the victim of a hate crime or hate-type criminal behavior, and whether it be anti-gay or cross burned on your lawn or bullying in the school bus or whatever, that we got legislative approval to file restraining orders against, so the individual who's being discriminated against doesn't have to go to court. The AG's office can go in and get that. That was done by our civil rights unit from a perceived problem and got legislative approval to do that. So we're mindful to protect all Vermonters, and when situations of discrimination are brought to our attention, we haven't been afraid to step up, whether legislatively or through enforcement efforts. So please call. Yes, Don?
You mentioned your relationship with the legislature and a number of particular issues.
Yep.
One of the things that your opponent raised has to do with that. Could you share with us your view as to what the appropriate relationship is between the Attorney General and the legislature, and where intervention is appropriate or not?
Okay, I didn't ask that question be raised, but I am really happy that you brought it up. Just for those of you who don't know, one of, at least at this point in time, the few things that my opponent seems to be criticizing me for is not working more closely with the legislature so that they will pass laws that will withstand challenge in the courts. And he's suggesting that we have not been there enough. And to that, and with legislators here in the room, I plead not guilty. The truth of the matter is, under state statute, we, when asked by the legislature, are to give legal advice on the constitutionality of what they're considering doing. And we do that. The legislature has legislative counsel, their own attorneys, whom they consult with on these things. But since we are called upon to defend laws that are attacked as unconstitutional in the courts, we don't just sit back and wait and just let the legislature do what it wants when they haven't asked us for advice. To the extent that issues that are of constitutional dimension are going through the legislature, usually they will ask, but we don't wait for that. And so we will go over, we will talk quietly with committee chairs or the Speaker of the House or the leadership of the Senate and say, you're considering this or that issue, it's potentially of constitutional dimension, and if you'd like, we would look into this. We will opine quietly or we will opine publicly, but you're getting into an area where you're pushing the envelope in this area of the law. We were in the legislature on the campaign finance law, where the legislature not only significantly restricted contributions to candidates, but for the first and only state to limit expenditures by candidates for elected office. And we said, you're going where no state has gone before, you're likely to be litigation. We worked with the legislature in putting together a public record that I think was over 60 public hearings or committee hearings on the issue, to have a huge public record to support what was done. We said we had good arguments, but there's risk. Legislature passed the statute, and one of the legislators on the floor said, we've already been told we're going to be sued if we pass this, but it's the right thing to do and we should do it. We have a right as a state to push the envelope. We were sued. We won at the trial level. We successfully defended. We successfully defended at the appeals court in New York City. And then we went before the most conservative U.S. Supreme Court in the last 100 years or so, and we lost. And I wish it was otherwise. But the court that later handed down the Citizens United case and changed over 200 years of legal history in this country and said that corporations are persons or individuals and have the rights of individuals when they're a creation of statute. That court was not going to allow Vermont to do what it tried to do on campaign finance. And similarly, same thing on the access to doctors' prescribing records for marketing purposes without the physician's permission. It was the Medical Society that came to me and asked me to push this legislation through. Maine and New Hampshire did the same thing. Federal courts in Maine and New Hampshire upheld the law. Trial court, federal court here in Vermont, the law was upheld. We lost 2-1 at the Second Circuit. U.S. Supreme Court ruled against us. Legislature knew they were running a risk, and they, I'll defer to the legislators here whether we were saying too much that there's risk, but we were not negligent in not apprising the legislature of the risk. And on the genetically engineered foods bill this session, a lot of Vermonters think that if they're genetically engineered foods, it ought to be on labels. In the same way the legislature a few years ago said mercury in consumer products ought to be labeled, and passed a statute requiring that. We got sued. We lost at the trial level, but it was upheld. We successfully defended at the federal appeals court level there. But here on the GMO issue, the legislature, we said there's risk. You're likely to get sued if you do this, and the legislature thought it's a good thing to have this required labeling, but we don't want to be the state that's first in line to have to defend doing this. And so the committee that took it up, our advice and Legislative Council's advice, put Vermont behind a year after California has a similar statute in effect and 2 northeastern states, so that we would be no less than fourth in line on this. It didn't pass the legislature, but that's an example of our going in and saying, be cautious. Do this. If you want to do it, fine, but do it knowing there might be litigation, and we'll see what the legislature does in January on the GMO issue. Yes, Senator.
I just, as one of 180 legislators, I have to say that the AG's office is always there when we call and ask, and sometimes when we don't. And sometimes we pay attention, and sometimes we don't. But I was glad Don asked that question, because I found that a little bit, I'm not sure what, annoying.
Yes, the suggestion that we haven't been there enough. And let me say something else, that if we believe a statute that the legislature enacts, whether they don't listen to us and just do it, or we haven't even heard it and they just do it, but if we think it's unconstitutional, then ethically we may not meet our ethical obligations and stand in front of a court and say it's no problem, it's all good. If we think it's unconstitutional, and we won't do that. But what we would do is we would, if the legislature really wanted this to went ahead and did it without our advice, then it would not be our office defending the constitutionality of something that we thought was unconstitutional.
But it's even more than just a constitutional issue. There's a good example of this is a number of years ago, we were rated the very last state in terms of advance directives and end-of-life decisions.
Durable powers of attorney.
Right, and we were dead last. And we worked very closely with Wendy Morgan. It wasn't a question of constitutionality at all, but she worked very closely with the Health and Welfare Committee to craft a bill. She's an assistant AG that ended up putting us on the top. So it isn't just where there's constitutional issues.
Oh, right. No, I'm just saying what we would defend. And actually, the last bill that got through the Senate this year was our package of consumer protection bills that Wendy Morgan had been working on all session, and we were worried that last day that it wasn't going to get through, but actually consumers in this state came out really ahead from this legislative session because of what the Senate did, in the last 10 minutes of the session or so to pass the legislation that changes the laws for a number of things in the consumer protection arena. And the President Pro Tem of the Senate has already told me a couple weeks ago that he wants this next session of the legislature to be a real consumer protection session too, and so I'm hoping to be there working with the legislature come January on consumer protection and other legislation. Thank you for the question, Don.
Well, what would it take to fight Monsanto? States like California joining you, they're kind of broke, I understand, in California, but...
Well, California's idea of broke and our idea of broke is different, but...
more states joining in, more lawyers...
Well, if the case is a case of constitutional dimension and we lose, we are liable to pay attorney's fees. And in the Entergy case, for example, right now, Entergy's legal bills at the trial level were $4.62 million. That's not to say that if they're ultimately win this fight, that we're going to have to pay $4.62 for the trial. But there will be questions of what's reasonable and what are Vermont lawyers' rates and everything. But we've paid out a little over $3 million in my 15 years as AG from lost cases at the U.S. Supreme Court. And, it's no fun to pay out $3 million. You know how much my office brought in last year into the state? Over $40 million. This year it'll be about $40 million. 2 years ago it was over $40 million. So in 3 years, $120 million in the door compared to over 15 years, $3.1 million paid out. It's not a close call. I don't like losing, But some suggestion that, gee, Sorrell loses all this money for us because he's a bad lawyer or he doesn't help the legislature to pass good laws or whatever, it's just not true. And the truth is, under our federal Constitution, what is not specifically reserved to the federal government is left to the states. And Vermont historically has been very happy to go out ahead of everybody else. First state to ban slavery in a state constitution. First state to give the right to universal male suffrage, the right to vote without regard to owning property. Those were radical ideas back then. And Vermont, in consumer protection, in personal privacy issues, in access to credit histories, in mercury labeling, any number of things, Vermont's gotten out ahead of the rest of the country. And the truth is, we've won over 90% of the time when Vermont's laws have been attacked. And do we lose one every once in a while? Yes. But if the standard that the legislature is going to bring to legislation is, if you're going to sue us, we're not going to pass this statute, then the laws in this state today would be very different than they are. And so I'm proud of the work we've done defending Vermont's laws. I wish we'd won every single one of the cases. But we work closely with the legislature, and I respect the work of the Vermont legislature.
What about the FDA in that instance? Are they worthless as far as standing up for the? What's the technical, legal reason Monsanto can say that they're hurt by the labeling?
Well, the question will be similar. We had two labeling cases. We had RBST. You know, growth hormone, artificial growth hormone in dairy cattle, in dairy, and the legislature passed a statute that said you got to label if you've got, RBST in your product. We got sued, and we lost. The reason we lost was we couldn't prove that the certainty of human harm or the risk of human harm was so high that it required the infringement on the freedom of the companies to have to put something on their labels. Compare that to mercury. We said, mercury in consumer products, you have to label. We got sued. We lost at the trial level. We won on appeal because we were able to show that mercury is really, really bad for you. And the question is, what kind of experts can we bring in to show that genetically engineered foods are more akin to mercury in consumer products than RBST? And the pendulum will go, the weight will go with the state if the health hazards are huge and provable. If they're not, if they're suspected but there's not adequate scientific proof of real health hazards from this or that product or element or compound being in a consumer product, then you're not going to be able legally to require the manufacturers or retailers of those products to label their products that those items are there.
How does that compare to having to have ingredients on foods? It seems, because they have to list the ingredients on foods.
Where it comes down is a lot of the ingredient requirements are federal legislation, okay? And so you don't have this one state setting a standard that impacts interstate commerce. Okay. And we do have our consumer fraud laws that we've enacted, for example, for Vermont products, where you can't say it's a Vermont product unless it was either manufactured or processed here or Vermont ingredients. You've got to have some truth so consumers can read and see if you legitimately are a Vermont you're a Vermont company and or that this is a Vermont product.
Could you say that GMO labeling is not Vermont?
Well, the reason, if Vermont passes a statute, it's the only state to do so or is first in line, then it will be a different standard and would be subject to the attack. That's why the legislature decided to get Vermont in line after several other states, including California.
But I mean, couldn't you say, like, how it's Vermont maple syrup, and that's a label, Vermont, right? So couldn't you say that Vermont has to be GMO-free to be Vermont?
that would be real uphill sledding. Okay. Yes.
In the nature of GMOs is that they're not natural. And I would think that in some respects that makes them much more like drugs that are artificially produced.
I have said publicly that I've been asked to look at the issue not of mandatory labeling of GMOs, but for those foods that on the label say they're natural, but they contain GMOs. Is there a violation of our existing consumer fraud laws, our labeling laws right now? And I've been asked whether I'll take a look at this, and the organization that has asked me to take a look at it is going to get me some information on that, and I said that I would take a look at it to see whether there's a possibility of an enforcement action under our current laws without the need for the legislature. Now, it would affect a much narrower scope of foods, but I said I would take a look at that.
On the other hand, it seems to me that these things should be regulated the same way that drugs are, because they're not natural. I would not be able to come up with a new synthetic form of sugar and put it out unless I could demonstrate that it was actually identical to the natural product. And in the case of GMOs, they are not identical to a natural product. They are synthesized, and they are not natural, and in some respects their effects are as unpredictable as thalidomide.
I think we're going to see that issue is going to be addressed in perhaps a variety of ways, potentially legislatively and potentially otherwise. I think we're early in the genetically modified organism battles.
Except for one thing, and that is that in the case of the genetically modified organism, we're talking about something that can get loose in nature. Drugs, like thalidomide, don't get loose in nature, or at least not very easily.
But the question will be the scientific or medical evidence to show that the harmful results of thalidomide versus GMOs. Yes, Tim.
I understand that you've got another appointment you've got to make, and I've heard 5 bells.
Okay.
Might be getting late.
Well, my campaign manager, even though he's a great Brattleboro guy, is going to beat me up if I am not on schedule. So,
That's right.
you've asked great questions, and I've really enjoyed this exchange. I hope you've learned something, one, and two, I hope you understand now even a little bit better the importance of the job of being Attorney General and the range of decisions that we make that affect your lives and your kids' lives and your parents' lives. And I hope you've heard enough to consider being supportive of my candidacy in the primary this summer. Early voting starts July 16th. The primary is August 28th. And then in the general election in November. So thank you all so very much.